my comments to a minimum because you just sat through the last hour with me. But I'm excited to moderate this panel. I'm happy I'm not sitting in between my two colleagues up here, but I think we have a great panel here that represent very passionate and very important views about campaign finance. The first on the panel, joining us by Skype, is Liz Kennedy, who is counsel at Demos and specifically works in the areas of political participation and voter disenfranchisement. Her writing has appeared in a variety of different journals. And before joining Demos, Liz was an attorney at the Brennan Center. So welcome to Liz via Skype. Then immediately to my left is Mr. Jim Bopp, and he is an attorney at his firm, the Bopp firm, and has really been involved in every, I think I can say this, maybe every major campaign finance issue, at least as far back as I can remember. His importance in the field, whether you agree or disagree with him, is rather immeasurable. And he is a Hoosier, found out a big college basketball fan, so graduated from IU. And as I said, he's spent his career fighting against various pieces of regulation, and it's great to be on the panel with him. And furthest over is a fellow Washington Nationals fan, Paul Ryan. Paul is senior counsel at the Campaign Legal Center in Washington, D.C. Specializes in a variety of areas, including campaign finance, ethics, and election law, and also litigates as well. So it's great to have Paul here as well. And also, it's very hard to have a major campaign finance occurrence happen and not see Paul's name sometimes in the same article as Jim. So it's great to have everyone here. And with that, I will turn it over to Liz.
Great. Well, thanks so much, Jason, and to Patricia and all the folks on the law review and the tech staff, of course, of Valparaiso, for your flexibility in setting up my ability to participate here through remote access. I am sorry that I'm not able to be there in person with you guys today, and wasn't able to be there for this morning's conversations, which I am sure were very interesting. It is really a great group to have been brought together, and of course a fascinating time. Congratulations on your prescient scheduling of the knowing that this would come just a few days after the Supreme Court's most recent blow against common sense, money in politics, and regulations. Can you hear me okay?
Yes.
Great, nicely done, good. Oh, I should have made this participatory. You guys all were very good. In any event, so what I will be speaking to today is about the Supreme Court, the Constitution, and the crisis of confidence in American democracy. And I should say, Liz Kennedy with Demos, and really glad we're having this conversation. So, first of all, it's just important to start by saying that really the Supreme Court has gotten the First Amendment supremely wrong in how it relates to money, matters of money in politics, with disastrous actual effects on our democracy and really our understanding of ourselves as an effective democratic society. So distorted by the court's past decisions, we've seen the current system of campaign finance laws and regulations already allowing a minute percentage of wealthy Americans to dominate the funding of our elections. So this is just a slide showing, the vast increase in money in politics that we are seeing cycle over cycle. And in fact, this really also shows the spike in outside spending that happened in the 2012 election cycle. I know that this morning, and then Jason as well talked about dark money, so I won't be talking about disclosure here. But the problem isn't really even particularly that the actual amount of money has skyrocketed to the extent that it has. The real problem is that the funding of American elections, so our politics, and thus our policy making, is just utterly dominated by the wealthy elite. So we know that candidates have relied on large donors for their campaign funding, for years. But the dominance by a tiny fraction of the US population over contributions and spending in support of candidates has really escalated in recent years. The Sunlight Foundation reported in 2012 that candidates got more money from a smaller percentage of the population than for any year for which that they had data. So what we're seeing in this slide is that of the money raised by congressional candidates from individuals, a majority of it came from people who donated over $1,000. It is, of course, unsurprising that the affluent are far more likely to make financial contributions than Americans. But it might be surprising to really see documented the tiny sliver of the folks that we're talking about. It's only 0.4% of the American population that even made a disclosed federal contribution of over $200 in 2012. So whereas about 2 in 3, 68% of wealthy respondents had made political contributions of over $200 in the past year. We also see that just 0.07% of the US population made campaign donations of more than $2,500 in 2012. So really, it's 86% of the members of Congress elected in 2012 and more than half of the members elected to the Senate in 2012 received more than received more money basically from these large donors than they did from this small group of what the Sunlight Foundation had referred to as the 1/10,000th of the United States population, a group of just 31,000 people. And we can see in studies that we did looking at the donations to SuperPACs, we saw that all of the money raised by small donors, by both Obama and Romney combined, which stood at $313 million in total giving, that minimum number of donors that figure came from was over almost 4 million donors, 3.7 million donors, and that it was only 32 super PAC donors giving an average of almost $10 million were able to give the same amount of money, in this case obviously in outside spending, but that really we're seeing the ability of the folks giving small donations is just being utterly crushed by the amount that is actually coming from the largest few. So I start with these numbers because I think it's important to contextualize what it is that the court has wrought, essentially, and to really look at what this campaign finance system means in practice. So, U.S. Senator Chris Murphy, and this is just one quote from, frankly, there are many examples where elected representatives are saying similar things. That basically, in order to be able to raise in this arms race where there's constantly more money and they need to find it from larger and larger donors, that what this means in practice is that they spend their time dialing for dollars, and another part of this quote says that he's only calling people that are basically making between $500,000 and $1 million, right? Because these are the folks that can afford to give, over $1,000 when he picks up the phone. So he's spending, dial time is 4 to 6 hours a day they're talking about needing to spend raising this money. And when they are dependent on the wealthy donors to raise this money, it means that they are spending all of their time talking to only the tiniest slice of America's wealthy elite and hearing from them about their public policy concerns. Chris Murphy saying, I talked a lot more about carried interest inside that call room than I did in the supermarket. These folks that I'm calling have fundamentally different problems than other people. So that in Connecticut, it's a lot of the problems that bankers have, but he's not really hearing about the problems that people who work at the mills or the factory floors have. So he says that he certainly has to stop and check himself The question is really whether we're going to be able to see our elected representatives checking themselves, or rather we are going to continue to see them merely getting out there and chasing big checks. So then, again, the problem is not, well, when we're talking, and as Chris Murphy exhibited in that anecdote, we also see reflected in social science research that shows that the actual public policy positions of the wealthy are fundamentally different than as reflected in these polls and these social science studies than the public policy positions of the majority of Americans. So one way to look at this, and this is particularly the differing policy issues of the wealthy, especially on questions about structuring the economy, have been well documented. These numbers are from a 2011 study, Democracy and the Policy Preferences of the Wealthy, and they show that while 78%, well, so this is showing that the wealthy respondents list a deficit as the most important problem, and that even though the general public does not agree with that, and that the general public cares, twice as much about unemployment as the wealthy respondents, and yet for years we've seen an austerity debate dominating our federal Congress and their time and attention, and not really enough attention being turned to the jobless economy and other economic issues. I will say there is another slide here that I will merely describe, since it was corrupted moments before this, no pun intended, presentation. But in that slide, it showed that 78% of the public supports a minimum wage high enough that no family with a full-time worker falls below the poverty line, but only 40% of the wealthy agree, which is again a nearly 2-to-1 disparity. And what we've seen is that we have not made progress on raising the minimum wage. It instead has been, the real value of the minimum wage has been flatlining for decades. Just this week, we saw a failure of the House to vote on a minimum wage package. So the point about the differing perspectives and differing public policy positions of the wealthiest of America isn't that is problematic in and of itself, of course. Everyone has the right to whatever public policy preference they may prefer. But the problem, so it wouldn't really matter as much if the policy preferences of the wealthy that are contrary to the majority of Americans was reflected also in the fact if their political power corresponded to the number of the people that felt that way about public policy rather than the numbers in their bank accounts. After all, and I think this is a critical element to remember when we're talking about any of these elements, as Robert Dahl reminds us, the assumption in a democratic society is that all citizens come to our political table as equals, that all citizens are politically equal in a democracy. And we talk about how really the size of your wallet should not determine the impact of your voice or your right to representation in a democratic society, because it is premised on the idea that we are all political equals. Unfortunately, as you see from this slide, research has shown that the government responds to the policy preferences of the donor class even when they differ starkly from the American public, particularly on economic issues. And Americans know that. So here, Martin Gilens in his seminal study, Affluence and Influence, shows that the American government does respond to the public's policy preferences, but that it is strongly tilted to the most affluent citizens, and that the preferences of the vast majority of Americans appear to have essentially no impact on which policies the government does or does not adopt. Larry Bartels, another professor and author of Unequal Democracy, showed in a study that the preferences of the people in the bottom third of the income distribution have no apparent impact on the behavior of government officials. At think this is really shocking evidence for folks who care about the health of our democracy, particularly because Americans actually, feel this and can see this and report that they know it. Americans believe that their representatives are more responsive to big donors than to voters, and that the improper influence of money on government blocks it from working to solve our current problems. Almost 80% are worried, this is a quote, worried that large political contributions will prevent Congress from tackling the important issues facing Americans today, like the economic crisis, rising energy costs, reforming healthcare, prior to the SEA, and global warming. And during the economic crisis, Americans reported feeling that the federal government is, quote, so corrupted by big banks, big donors, and corporate lobbyists that it no longer works for the middle class. So, here's how this plays out. What we have seen as a result of the system of campaign finance that has set up these incentives and these dependencies and shut out so many of ordinary Americans from having a voice that can be heard by their government in public policy debates is that we really are seeing a vicious cycle. The court's decisions have exacerbated fundraising dynamics that pressure elected representatives to favor the policy preferences of those they depend on for financial support. Elected officials are frequently raising money from the very industries that they are charged with regulating effectively in the public interest. Those interests are those in positions, here's how we see this vicious cycle. Those in positions of economic power can use their financial resources to support their favored politicians, and in turn, those elected officials can use their political power to further their economic interests of their high-rolling financial supporters. So this is a situation which is really showing essentially a capture of government. If people are familiar with the phrase regulatory capture, we now have essentially a capture of government by these concentrated private economic interests, which is in derogation of the duties of elected representatives to act in the interests of their constituents and the country as a whole. So let's look at some of the court's decisions, turning now, and how we got here. To take a step back, the role and look at the role of the Supreme Court generally, and kind of how it comes, where it sits in this process of determining our nation's campaign finance system, something that Bert Newborn refers to as, well, that's fine. But so we have to remember that this process starts with our desire and our entitlement as politically equal citizens to have a government that is responsive to our needs and really the broad-based, bipartisan, and well-documented support amongst the American public for real reforms that fight the corrupting power of big money in politics, right? So these laws don't just come kind of from whole cloth or just out of the ether or what have you. It's not like when we finally managed to pass common sense money and politics protections, it's really because the American people are demanding of their government that we have laws and common sense rules in place. So we saw, over a century ago, in the age of robber barons and trust busting, President Teddy Roosevelt called for one of the first campaign finance laws. And then later it was in response to the campaign finance scandals of Watergate that led to the creation of the Federal Election Campaign Act. Now, of course, laws in our constitutional system cannot merely be adopted by a majority. It's important that they are constitutionally invalid if they improperly burden protected rights without sufficient justification. But so let's say we managed to get government to pass a law to protect democratic government from being dependent on big money and responsive to voters. Then the court has been applying a balancing test, right? As to whether it burdens a First Amendment right without sufficient governmental interests. What this court has done is to pervert the both sides of the balancing test, essentially, and dismiss, oversell the actual burdens on First Amendment rights, and dismiss almost all, amputate and then deform other critical governmental interests that undergird the government's responsibility to regulate and legislate in this area. So we've seen that, shaped by the court's past decisions, the current system, is allowing this minute percentage of wealthy Americans to dominate the funding of elections and hobbling our attempts to protect government from this kind of capture. And how did they do this? Well, first, in Buckley v. Vallejo, they found properly that limitations on money in politics prevent the real or imagined coercive influence of large financial contributions on candidates' positions and on their actions if elected to office. So here we're, at least in this seminal case, as you all I'm sure know, they're still working with a place where they're thinking about the real or even imagined coercive influence from these large financial contributions and keeping that in mind as they then carve out space for protections. They also add a line that the concept that government may restrict the speech of some to enhance the relative voice of others is wholly foreign to the First Amendment. Let's put a pin in that. We'll come back to that when looking at McCutcheon. So the court for almost 40 years has moved back and forth in narrowing and widening these compelling interests that can justify laws regulating money in politics. So fast forwarding to the case Nixon v. Shrink Missouri PAC from 2000, this is an instance where this court understood that corruption of government is not confined to mere bribery of public officials, but rather extends to the broader threat from politicians too compliant with the wishes of their large contributors. Exactly what we see going on. And that by limiting the size of the largest contributions, such restrictions aim to democratize the influence that money itself may bring to bear upon the electoral process. I pause here also to include this element from Justice Stevens's concurring opinion, because it's important not to lose sight of the fact that though in Buckley, because they essentially found, and certainly when they struck down spending limits, that that has gone down in our history colloquially as the decision that says that money is speech. And Justice Stevens really takes that on, and that is why, of course, it is a core First Amendment, burdening core First Amendment rights when there are money in politics regulations. So the court, some members of the court have said it and continue to say. However, others are have really raised up the point that actually money is not speech. And in fact, spending money in support of your political speech is actually conduct. And that even though there may be First Amendment concerns here, it is not the case that the First Amendment should provide the same measure of protection to use money to accomplish such goals as, inspiring volunteers, as it provides to the use of ideas to achieve the same results. Essentially, they say the right to use one's own money to hire gladiators or to fund speech by proxy certainly merits significant constitutional protection. Those property rights, however, are not entitled to the same protection as the right to say what one pleases. And I think that's critically important to keep in mind that that is really a live issue that we, in fact, need to return to. But moving forward, the court then in McConnell v. FEC really emphasized the consequences of constraining the government's power to act in response to public demand. They said that the possibility that legislators will decide issues not on their merits or the desires of their constituencies, but according to the wishes of those who have made large financial contributions valued to the office holder, is, while a more subtle form of corruption, still equally dispiriting. And then this is really a key quote, that taking away Congress's authority to regulate the appearance of undue influence means that the cynical assumption that large donors call the tune could jeopardize the willingness of voters to take part in democratic governance. And I think, if you just think back to a few slides ago, this is really what we are hearing from the American public, that is exactly where a lot of people actually are. I think, I think I'm talking about this later in the slide, but to bring it up now, there was one study that the Brennan Center did of unlikely voters showed that the majority of unlikely voters registered that the reason they were unlikely to vote was because government was so corrupt. So it really is a question, and by that, we'll get there. But this is really, having actual impacts on participation. So then we turn to Citizens United v. FEC. In this case, the court has explicitly, and through a few, the beginning basically of the Roberts Court, the court was explicitly rejecting rationales beyond corruption and significantly narrowing the scope of the corruption interest. And here, we see the court, beginning to narrow again corruption to merely quid pro quo exchanges, even declaring that independent expenditures cannot corrupt as a matter of law, and overruling Austin, which was another case discussing the broad-based nature of corruption of money and politics in our democratic society, and part of McConnell. That was decided, less than a decade prior to this case. However, in Citizens United v. FEC, Justice Kennedy did allow that if elected officials are succumbing to improper influence, if they are surrendering their best judgment, and if they are putting expediency before principle, then surely there is cause for concern. Well, as we have seen and as we will see, there is significant cause for concern. But I will now pause, and I'm sure that Paul Ryan will be taking you through, and others will be taking you through more specifics of the McCutcheon decision. But in the context of this conversation, turning next to what McCutcheon, the FEC, has actually done this week. So obviously we know that this case struck down aggregate contribution limits, which had capped the total amount of money individuals could give to federal candidates, parties, and PACs at $123,000, sorry, that should be $123,200. It's interesting to note that that aggregate contribution limit was already twice as much, more than twice as much, as the median income, or of the income of the median American household. So again, when we're talking about whose rights are really being burdened here, it is certainly not, 99.5% of Americans in this instance. So they striking these limits will now enable, through joint fundraising committees, a single wealthy donor to contribute $3.5 million to one party and its federal candidates during an election cycle. And Justice Breyer's dissent calls out that this decision is eviscerating our nation's campaign finance laws, leaving a remnant incapable of dealing with the grave problems of democratic legitimacy that those laws were intended to resolve. We have projected that as a result of this decision, and this is from Demos and US Berg, as a result of this decision, more than $1 billion in extra McCutcheon money will come into candidates, parties, and their committees through the 2020 cycle. So, you can see the projected giving of the folks that were identified as the about 1,200 elite donors who have been close to or at the aggregate contribution limits when they were in existence. And they, at that point in 2012, they had given about $155 million. But we projected that had these aggregate contribution limits not been in place, they would have given nearly 50% more, about over $450 million. And again, to contextualize they would be giving actually 100% more. But that $450 million would have been 50% more than the amounts that President Obama and Governor Romney raised from all of their combined small donors. So that's really, again, when we're talking about the ability of the smallest few to be able to dominate our political discourse more and more at the expense of having ordinary Americans be heard in this political discourse. And the key thing to remember that Justice Breyer points out in his dissent is that the First Amendment advances not only the individual's right to engage in political speech, but also the public's interest in preserving a democratic order in which collective speech matters. That is something that basically when he's talking about, looking now at the third quote, a fundamental principle of our constitutional system is the maintenance of the opportunity for free political discussion to the end that government may be responsive to the will of the people. But when the voices of the non-elite donors are so overmatched, then they are in fact, we've seen that government is in fact entirely non-responsive to the will of certainly the folks in the bottom third of the economic distribution. And then really when the public policy preferences of the bottom 90% don't accord with the public policy preferences of the top 10%, then we're seeing government is not responsive to the will of the people. So it's, again, I think it's important to note, particularly when we're looking at the different work that Chief Justice Roberts is doing in all of the campaign finance cases that have come out in his tenure, and then particularly in this decision, they seem to be coming from a position where they're thinking that this political speech is somehow just occurring in some kind of platonic ideal. But this is not, I think Justice Breyer addresses that very well, saying that political speech does not exist in a vacuum, that in fact political communication seeks to secure government action. And we've seen that they, in fact, very, very frequently do secure that government action to be responsive to their values rather than those or of the majority. So Justice Roberts wrote, and I'll just read this, it's not in a slide, that in assessing the First Amendment interests at stake, the proper focus is on the individual's right to engage in political speech, not a collective conception of the public good. That is because when they've narrowed the conception of what is going on, the work that money and politics protections are doing, merely to this very essentially orthodox, deregulatory, libertarian view of saying it is merely about this one particular element that the First Amendment and that in fact our entire Constitution is really meant to protect. But actually, as Breyer points out, Americans through our government have an interest in maintaining the integrity of our public governmental institutions, and we don't see the Chief Justice concerned with that at all. And I will wrap shortly, this is very short. So, in fact, so what we actually see, but we know that the American public is far more concerned, here we go, with has a much richer understanding of what corruption actually means than the current Roberts majority. So even though Chief Justice Roberts said in the decision that spending large sums of money in connection with elections, but not in connection with an effort to control the exercise of office holders' official duties, does not rise to quid pro quo corruption, Americans understand that it is corruption when, for example, when financial supporters have more access and influence with members of Congress than average Americans. Over 80% of Americans, huge bipartisan majorities, are disagreeing with the court's view that only quid pro quo, essentially bribery, is a corruption of government. Yeah, 57% of Americans are saying that it is very corrupt when financial supporters have more access and influence with members of corruption. So when the deck is stacked, what we see is that wealthy and big industries get policies that reinforce their advantage, and that citizens are not able to access their, speak to their representatives and have them fairly weigh the interests of all of their constituents. And what's ultimately at stake is how much say a citizen has in shaping the policies that govern her life. And instead, there are several measures that show the alienation of people currently from their government. I will just close with this one, showing that confidence in Congress is truly at historic lows. And while some posit that the loose rules that we now have, essentially barely any rules in protecting our government from big money in politics, that these rules will inevitably lead to a big scandal, the truth is, the scandal is what is legal today. Because the First Amendment should protect more than just an individual. It protects our ability, in fact, to engage in self-government, to be heard by our representatives. And that is what is in danger of being lost. Because now, government won't even be able to hear, we'll be able to hear from the voices of a greater group of people even less. And our politics risks devolving into merely a disagreement between rich people. So we see here with only 10% of Americans having confidence in Congress, the lowest rate of any confidence in any institution since Gallup started measuring this, by the way. That this is the alienation that prior courts have warned of in cases like Nixon and McConnell. It is only this court that is blind to the reality of corruption of our government and blind to this reality of the crisis in confidence in American democracy. I'll close by saying that Justice Brandeis warned that the greatest menace to freedom is an inert citizenry, and that alienation is exactly what we're looking at today. The one note of hope is that this is really, a pretty unstable, contested 5-4 majority, and that when the court has been this wrong on this critical of an issue for our constitutional democracy to really move forward, we've seen them reverse themselves on issues like segregation. We saw them reverse themselves on issues like substantive economic due process, and there will come a time when they understand that they need to reverse this perversion of the First Amendment and return our self-government to the people. So thank you so much.
Thank you. And now I will turn over to Jim.
Thank you very much. Paul and I were just discussing that since this is a tag team and Liz went over 15 minutes, it had all come out of his time.
Which means I'm done, thank you.
Anyway, as you see in the schedule or program, I was scheduled to speak about SuperPAC. And since SuperPACs have arisen through Wisconsin Right to Life and Citizens United, both of which were my cases. And in fact, in 2003 and 2008, I won the very first SuperPAC cases in the Fourth Circuit, the federal Fourth Circuit. I was really anxious to talk about that question. But since McConnell is also my case, and it's hot off the press, I can't resist really focusing on that decision this afternoon. Now, with respect to the aggregate limits for reformers, the question is really simple. Or Citizens United, the corporations and labor unions were freed up. The answer to it is really simple. First, what you do is you identify who it is among the American public that is opposing, you think is opposing your liberal agenda, and then you figure out laws that will attack them and suppress them, shut them up, so that the will of the people, that is absent these people, will prevail and you'll get your liberal agenda. Or Citizens United, it frees up both corporations and labor unions. But what is the reformer recommendation in dealing with Citizens United, only regulating corporations, because they might actually have the audacity to support Republicans, but we're not going to restore any restrictions on labor unions because we know who they support. Well, I don't think it's about picking out your enemies to your liberal agenda or your conservative agenda. I think it's a much more fundamental question than that, and that is whether citizens of all stripes and every point of view is going to have the freedom to access our political system and participate in it, and rather than having a system in which the government decides whose voices are going to be heard because they make a decision, the government makes a decision, and that means, of course, incumbent politicians, on what voices are worthy to be heard within our democratic society. Now, let me first talk to you about the origins of McCutcheon. Soon after Rice Priebus was elected chairman, he came to me and told me that one of the biggest problems that he had in fundraising were the aggregate limits. Because the aggregate limits created three pools of money. One pool of money was about $42,000 that a donor could give to all candidates in the 2-year election cycle. That means that you could only support 9 candidates to the full amount permitted by law, the $5,200 provided by law. And if you gave to a 10th the full amount, you've committed a crime. As to national political parties, they created another pot, which is maxed out at a little over $70,000. Now understand there are 3 national political party committees, the Senatorial Committee, the Congressional Committee, and the RNC. Each can receive in excess of $30,000 per year, which gives you about $180,000. But the individual is limited to giving just over $70,000 to all 3 of those committees. Now, the other complicating factor is within that $70,000 is another pot of money. And this pot of money is about $42,000, and that limits the amount that you can give to all political action committees and all state political parties. So if you supported your local state party with a $10,000 per year contribution, which would be lawful, that's $20,000. So you'll be down now to $50,000 to support all the 3 national political committees of one of the national parties. So Rice was in competition, not working with, but in competition with the Congressional Committee and the Senatorial Committee, and the overall limits were so low in comparison to what the legal amount that could be contributed that it was dramatically adverse to the fundraising goals that he had. So he asked me whether or not we could attack that law, and if so, I had handled other cases for the Republican National Committee, and at that time I had 12 cases decided by the United States Supreme Court on the merits, and I had won 9. And all of them were campaign finance, First Amendment type cases. So he wanted me to do this if I thought it had merit. And that's, as we were working on it, that's when Sean McCutcheon came on the scene, because Sean had filed an Federal Advisory Committee request asking the Federal Election Commission if they were still going to enforce the aggregate limit. Now, there wasn't really any court decision at that time that would suggest that they shouldn't, and in fact, the only law on the subject was Buckley decision in 1976 that upheld the predecessor version that limited aggregate contributions to candidates, PACs, state parties, and national parties to $25,000. So there wasn't any real reason even to ask the question, but they gave the obvious answer, of course they would, and then they called me. They didn't know about the RNC. They called me and said that they really didn't have the expertise to bring the case, and they asked if I would be willing to do that. So over the next few weeks, I put these 2 clients together. The RNC certainly wanted to see the aggregate limit on candidates also struck down because it hurt both Republican, and they're concerned about Republican candidates, but it hurt all candidates in terms of their fundraising. And they wanted to see that whole structure to go down, and they really did need a donor in order to challenge the candidate limits. So I put them together. The lawyers that contacted me kind of went to the background. We prepared all the case and the pleadings and the arguments in the district court, represented both parties, to the United States Supreme Court, where we got the case accepted for review by the Supreme Court after we had lost in the district court. It was at that time that the McCutcheon people decided to file their own brief, and which seemed a little odd since they said they couldn't handle a district court case, but in any event, that's the way it played out. They filed their own brief. I represented the RNC, and as you've all heard, we jointly were successful on Wednesday. The Republican National Committee paid the freight for the bringing of this case, and it would have never happened without them, and they deserve the credit or blame, depending on how you look at it, for the results. I also didn't give credit, of course, to Justice Roberts and the 5-member majority, because after all, they are the ones that write the decisions and vote for them. Now, the rationale of McCutcheon. A lot of things have changed since 1976 when the original $25,000 limit was upheld. At that time, there was only a base limit on candidates, and that was $1,000. As to PACs, state parties, and national party committees, you could give unlimited amounts, except for the aggregate limit. In other words, there was no base amount to each one of those, but the aggregate limit meant that you could only give up to $25,000 to all of those combined. So it served also as a base limit if you just wanted to contribute to one past state party or national party committee. Now, in the McCain-Feingold legislation adopted in 2002, they broke they increased and broke that aggregate limit down into the 3 pots that I have described. But also the last several decades, there has been a lot of other laws passed defining earmarking. You give if I give a contribution to Jason, and Jason gives it to a candidate, but I say, here, Jason, give this to a candidate, that's earmarking and is attributable to me, in addition to him, actually, but it's attributable to me as the original donor. Also affiliation rules, so you couldn't create a dozen PACs and you fund all the PACs and have them each give contributions to a candidate. They adopted affiliation rules, putting them all together under the same limit. They adopted transfer rules. They established joint fundraising committees. And what actually had happened was every problem that the Supreme Court identified in Buckley as justifying the aggregate limit was solved by all these new laws and all these changes that had occurred. The base limit and these other new laws. So the question then became, all right, all the problems have been solved. What is the justification for the aggregate limit? And of course, we've heard it here. And that is that they targeted the wealthy because in their view, the wealthy oppose their liberal agenda, and they want to do something about them. They're standing in the way of their policy preferences. So they want to drive them out of the political process somehow so they can get, the government will be more responsive to their political ideology. Now, ironically, they're wrong about that. And I don't know why, if all they care about is partisan politics, why it is that they don't like the wealthy. Do you realize that of the richest congressional districts in the United States, the ones that have the highest per capita income, 80% are represented by liberal Democrats. 80%. So when the rich go to the ballot box, they vote for liberal Democrats, not for Republican conservatives. We have a really interesting situation in our country where the wealthiest and the poorest are both supporting the same party, the Democrats, and it's a vast middle class that is supporting the Republicans. Well, when this case, all these changes in federal law that has occurred then raise the question for the court, what in the world is the justification for this limit when all the problems have been solved? And what they said was the only justification that they could figure out was leveling the playing field. That, of course, she just told us that's what they're all about and what they want, and that has never been held to be a justification for restricting speech. You think somebody's speaking too much, that is not justification for limiting them. Now, the second thing they did is narrowly define the interest in corruption. That is to only quid pro quo corruption, not to access and not to gratitude. Now, think about this for a minute. If it would broaden in the way that the reformers, who just, they never found political speech that they liked, that they didn't want to limit and prohibit, if you said that corruption is if a candidate feels gratitude toward another person because of their speech activity, their support, let's say, for that candidate. Let's say it's corruption because a politician naturally will be grateful if an editorial writer in your local paper writes an editorial supporting that candidate. If gratitude was corruption and we can prohibit speech that causes corruption, then we can prohibit newspapers from doing editorials. Well, how about a celebrity wants to endorse a candidate? Well, certainly the politician is going to feel grateful for that endorsement. Well, if that's corruption, well then celebrities can be prohibited from endorsing candidates. In other words, the natural, beneficial, salutary human emotion of gratitude is converted into corruption and a justification for prohibiting any speech or punishing it, throwing people in jail for any speech that causes a politician to be grateful. Obviously, the Supreme Court is just flat out not going to do that. Expand corruption in such a way that normal, everyday political activity is now criminal, or could be made criminal under our laws. Now, what has been the response on the other side? Well, there's been a couple of them. One is to posit wild hypotheticals that defy reality. That you can put together 100 candidates. Think of this, 100 candidates. Have some rich guy give to all these 100 candidates who would then give all this money to a particular candidate. This is how they get to this $3.5 million. It's a joint fundraising committee where there's still limits on every one of the participants, but that you have state parties, say 50, you have the 3 national party committees, you have hundreds of candidates, and they all get together to accept a contribution from one person of $3 million and all give it to a particular candidate. Isn't that absurd? There has never been in history anything like that. Under current law, if you could put that kind of scheme together under current law, you could funnel $123,000 to a particular candidate. Well, that ain't chump change. So if you could do it, if it was a reality, well, then you would be doing it. You would see joint fundraising committees with a whole bunch of candidates joining state parties and national parties to rack up $123,000 and give it then to a particular candidate. Never happened in the history of our country. So these are fanciful, defying realities. Now, of course, there are joint fundraising committees. Both Obama and Romney had them. What they involved was their campaign, the DNC or the RNC, and 2, 3, 4 state political parties. And some of them were for $50,000, some of them were $75,000. I don't know any for more than $70,000, and none of them were ever for $123,000. But no, they're not. I mean, you can't even do it for $123,000. They think you can do it for $3.5 million. Oh, come on. Now, the second thing is they respond to all of this to say that individual freedom of speech, which they do acknowledge, and Justice Breyer in the dissent does acknowledge that contributing is an individual an act of an individual that is protected by the First Amendment freedoms. He acknowledges that. And in fact, he joined an opinion in 2006 in a case that I also argued before the U.S. Supreme Court out of Vermont, where he joined 6 members striking down Vermont's contribution limits as being too low, and because they violated the First Amendment. So what he says is that collective speech, if you add together the speech of everybody, the government can look at that speech and say, well, does that speech reflect the will of the people? And if it doesn't reflect the will of the people, because, as you heard her, the rich can speak too much, well, then we can prohibit individual First Amendment activity in order to bring the collective speech into balance with the will of the people. Well, wow. You know, so in other words, we can attack the freedom, acknowledge freedom of individuals because we are defending the people. You know, this is not a new argument. This is a historic argument that has been going on for centuries. And that is freedom and democracy the way for the people to participate in their government and the way for democracy to work? Or is it for the government to decide what the will of the people is and then violate their individual rights if we think that their speech interferes with the will of the people? Now, you just heard her go through this exact exercise, and that is the first thing you do is identify who are the people that you're seeking, you want the government to protect. And she said it's a great middle class. I agree with that. They vote Republican, as it turns out. But you know, I agree with that goal. You know, they're good people, and I consider myself part of them. All right, and then you pick out the enemies of the people that are distorting their will. Well, who are those people in her scenarios? It's the rich. The rich, they're going to speak too much. So what we're going to do is then target them and prohibit them and limit them and deprive them of their freedom. You know, so this is a prescription for tyranny. This kind of exercise has been done in the last 100 years in multiple countries. You know, Pol Pot thought the enemy of the people, who he conceptualized as the rural people, the enemies of the people were the people in the cities. So when he took over, he emptied the cities. You see the communists, the proletariat is the people. And who's the enemy of the people? The bourgeoisie. You see this over and over again in history. We're protecting the people by government suppression of freedom and targeting segments within the population as the enemies of the people is the totalitarian states. This is a great debate. You know, is the government going to be in charge, or is it going to be the people in charge? Are we going to have freedom, or are we going to have government dictates? Well, the First Amendment unambiguously placed our government on the side of freedom. Because when it said that the Congress shall adopt no law abridging the freedom of speech, without question they're talking not about individual speech, because after all, when does the collective speak? Together. I suppose you get a mob together. and you have them chant like the occupiers do. You have them all chant. I suppose that's a voice of the people, but that's association. They mean something bigger than that. Who is this voice of the people that they want? They think that the government should be able to bridge freedoms of individuals on behalf of. Anyway, it's a very pernicious doctrine. It sets the First Amendment absolutely on its head. And I would be more charitable to say after reading Ordered Liberty that Justice Breyer thinks he is writing a First Amendment, not interpreting one. He thinks that it's his job to balance the First Amendment interests and then decide what the First Amendment said. Well, actually what happened is that the founders of our country balanced the First Amendment interest and came to a conclusion. And that was on the side of the people and freedom and against the government, abridging those freedoms because the government thinks it'd be a good idea to do that. And so Justice Breyer would set set the First Amendment on its ear because essentially he thinks he's writing a First Amendment, not interpreting and applying one. It is distressing that 4 members of the Supreme Court would adhere to the whole idea that the government can willy-nilly violate people's individual political rights, First Amendment rights, because they think it better serves what the government decides to be the will of the people.
Turn over to Paul, who probably agrees with
Mostly, Jim and I mostly agree. A few points of difference that I will try to focus my remarks towards. But first off, it's a pleasure to be here. Thank you for all of those here at the law school who put on this great event. One tip for the law students who are present, something I did not learn in law school that I wish I had learned in law school, which is if you have any interest in engaging in Supreme Court type litigation, appellate litigation that will go to the Supreme Court, what matters more than anything else is counting to 5. And my discussion today is going to highlight that, how important counting to 5 is, because when you boil it right down, what we have from over the past decade, going from the McConnell decision to this week's McCutcheon decision, is a change in the court composition. We have a 5-4 vote going one way in McConnell on a very important point of law, and now this week in McCutcheon, a 5-4 vote going the other way on this very important point of law. The Constitution didn't change. The First Amendment, no changes in the past 10 years. The statute at issue have not changed. All that has changed is the composition of the court. So, when I was invited to this event a couple of months ago, I thought, okay, McCutcheon's on the radar. What will I talk about? I'll talk about McCutcheon and whether or not a decision in the McCutcheon case will or could result in a recreation of the soft money system, the return of soft money. And some of you may not be familiar with the soft money system, so I'm going to talk about that for a minute or two, and then move on to discussing the substantive law at issue here in McConnell, to a limited extent Citizens United, and then McCutcheon, and talking with respect to McCutcheon about some nuts and bolts mechanics of how that decision will likely play out. So, soft money was money that was being raised by parties, often solicited by office holders, outside of federal contribution limits, including the, at the time, $25,000 aggregate contribution limit that was enacted in the 70s and upheld by Buckley. It resulted from some FEC interpretations of the law, and over time, over decades, through the 80s and 90s, the law became that if a party was not using the money to engage in express candidate advocacy, it could raise money outside of these federal limits to pay for that other activity, that non-express advocacy activity. The soft money raised by parties, they got really good at raising this out-of-limit money, or above-limit money. In the early 80s, it made up about 5% of their coffers. In '84, the parties, the Democratic and Republican parties collectively raised about $21 million. By 92, it had gone up to 80 million, which represented about 16% of the major parties' coffers. By 96, went up to 272 million, which was about 30% of their coffers. And by 2000, it had reached about 498 million, according to the record in the McConnell litigation, which constituted about 42% of the two major parties' coffers, money raised outside of the federal limits, including money raised above the then, in effect, aggregate limit. So in 2002, Congress passed the McCain-Feingold Law, which election lawyers often refer to as the Bipartisan Campaign Reform Act, or BICRA for short. One provision in BICRA outlawed parties and candidates and office holders raising soft money. It prohibited candidates and office holders and party officials from soliciting, directing, receiving, transferring, or spending any money outside of federal contribution limits in connection with any election. BICRA also amended the aggregate contribution limit. It increased that limit to $95,000 with changes in the cost to reflect changes in the cost of living. So at the time of the McCutcheon litigation, as of this week, the limit was $123,200. So it had increased substantially from the $95,000 upon its enactment in 2002. The soft money ban in BICRA was challenged in McConnell v. FEC. Right after the enactment of the law, both parties went to court and sued the federal government for the law that both parties' members had just passed on a bipartisan basis, hence the law's name. And in that litigation, at the district court level, a record consisting of more than 100,000 pages of material and testimony from more than 200 witnesses was compiled. In that 100,000 plus pages of material and 200 witness testimony, no quid pro quo evidence was in that record. Justice Breyer, in his dissenting opinion this week in McCutcheon, described it this way. The district judges in McConnell made clear that the record did not contain any evidence of bribery or vote buying in exchange for donations of non-federal money. Indeed, no one had identified a single discrete instance of quid pro quo corruption due to soft money. But what the record did demonstrate was that the enormous soft money contributions, ranging between $1 million and $5 million among the largest donors, enabled wealthy contributors to gain disproportionate access to federal lawmakers and the ability to influence legislation. There was an indisputable link between the generous political donations and opportunity after opportunity to make one's case directly to a member of Congress. Justice Breyer includes an appendix to his dissent in this week's McCutcheon decision, going through some of the more interesting, shall I say, excerpts from that record. But to put it bluntly, the McConnell court back in 2003, it flatly rejected the argument that corruption must be limited in terms of what can be regulated only to quid pro quo activity. The McConnell court stated that the plaintiffs in that case conceived of corruption, quote, too narrowly, and that the court's cases had, quote, firmly established that Congress's legitimate interest extends beyond preventing simple cash for votes corruption to curbing undue influence on an office holder's judgment and the appearance of such influence. Justice Kennedy, back in McConnell, he was in the dissent, and the majority referred to Justice Kennedy's view. He was advocating that only regulation of quid pro quo type corruption was permissible. The majority referred to that, in reference to Justice Kennedy's view, they wrote, "This crabbed view of corruption, and particularly of the appearance of corruption, ignores precedent, common sense, and the realities of political fundraising exposed by the record in this litigation." So, robust record, over 100,000 pages of material. By contrast, in McCutcheon, there was no record in that case. There was no factual record for a variety of reasons, and it's referenced and discussed in both the plurality, Chief Justice Roberts' plurality opinion, as well as the dissenting opinion in McCutcheon. But back in McConnell, there was a huge record of what happens when you have federal office holders soliciting big contributions. And what was found in that record was that you get access and influence that the court at that time determined was a form of corruption. The critical characteristics of the, quote, soft money that were at issue in McConnell, I believe, were that the contributions were large, many exceeding $1 million. The contributions were solicited by office holders for their parties, not for the candidates or office holders' own campaign committees, and that these large contributions resulted in undue access and influence for the donors, which the McConnell court considered to be a form of corruption that justified regulation. So one of the questions after McCutcheon is, will the McCutcheon court's invalidation of the aggregate limits effectively recreate this corrupt soft money system? Meaning a system in which office holders are soliciting big contributions, $1 million plus contributions, for their parties, and in exchange giving preferential access and influence to mega donors. The McCutcheon court's invalidation of the aggregate limits, at the end of the day, may matter less than some of the content of the McCutcheon decision, unrelated directly to the dollar amount or striking down the limits. And I'm talking about the court's perceptions or definition of what constitutes corruption today. But it didn't start in McCutcheon. Citizens United gave us some hints about where the court was going with respect to corruption. So in Citizens United, in the context of independent expenditure limits, a prohibition on corporate and labor union independent expenditures, the Citizens United court wrote, when Buckley identified a sufficiently important governmental interest in preventing corruption or the appearance of corruption, that interest was limited to quid pro quo corruption. The fact that speakers may have influence over or access to elected officials does not mean that these officials are corrupt. The appearance of influence or access, furthermore, will not cause the electorate to lose faith in our democracy. Ingratiation and access, in any event, are not corruption. Pretty big change. Composition of the court changed by one vote, and all of a sudden, what was corruption in 2003, undue access and influence, is no longer corruption. That's where we were in 2010 with Citizens United. So if access and influence are no longer a form of corruption that can be regulated by Congress, was the BICRA soft money ban unconstitutional as a result of the Citizens United decision? Well, the court backstepped away from that question. In the opinion itself, the court wrote, the BICRA record establishes that certain donations to political parties, called soft money, were made to gain access to elected officials. This case, however, is about independent expenditures, not soft money. So does corruption mean different things in the context of independent expenditures or versus in the context of contributions? Well, let's skip ahead to McCutcheon. The Campaign Legal Center was involved in McCutcheon from the very beginning of the case before the district court. We filed an amicus brief in the district court explaining to the court how we believed joint fundraising committees, a mechanism that had been around for a long time, would be used in the absence of aggregate contribution limits to effectively recreate a soft money system where office holders are soliciting $1 million checks or $1 million plus checks. The FEC did not make that argument before the district court. The district court relied on that possibility of corruption as it was defined in McConnell and upheld the aggregate limits. The district court in the process cited our amicus brief, and if you spend most of your time writing amici briefs, you realize that it's not very often that you get cited in court decisions where they excerpt portions of your amicus brief that happened before the McCutcheon district court. We then filed a brief before the Supreme Court making the same arguments largely in great detail and specificity. And once again, our brief was cited by Justice Breyer in his dissenting opinion and was cited by reference by the plurality in Chief Justice Roberts' opinion, discounting our views, of course, in the plurality opinion. So, a couple of important aspects of McCutcheon. First, the continued narrowing of the definition of corruption. What constitutes corruption? What the court wrote in McCutcheon this week is they took it one step further, arguably, than where they were in Citizens United. In Citizens United, they said, yeah, access and influence isn't corruption. What we really mean by corruption is quid pro quo. And they kind of seemed to leave it at that. They got more specific this week in McCutcheon. They said, we have said that government regulation may not target the general gratitude a candidate may feel toward those who support him or his allies, or the political access that such support may afford. Ingratiation and access are not corruption, a point for which they cite their own opinion in Citizens United 4 years ago. Any regulation must instead target what we have called quid pro quo corruption or its appearance. And this is where it gets good. They wrote, that Latin phrase captures the notion of a direct exchange of an official act for money. Campaign finance restrictions that pursue other objectives, we have explained, impermissibly inject the government into the debate over who should govern. So, set that piece aside for a minute, but they've narrowed even further the definition of corruption. Another big issue in McCutcheon was the standard of review that the court would apply to the challenged aggregate limits. This is something we were really worried about on the pro-aggregate limits side of the debate, because the plaintiffs in the case were arguing creatively, I think, that these aggregate limits, they look like contribution limits. Well, I'll take one step back. Those of you who haven't read Buckley or taken election law, In the Buckley case back in '76, the court distinguished between contribution limits and expenditure limits. They subjected contribution limits to what they called closely drawn review, and they upheld them. They subjected expenditure limits to strict scrutiny, and they struck them down. And as most of you know, strict scrutiny, there's a saying that goes with strict scrutiny, which is strict in theory, fatal in fact. When the Supreme Court announces it's applying strict scrutiny, you can bet that the law is going to be struck down in another sentence or two later. So we were worried about this, that the court would buy this argument that the aggregate limits were a lot more in practice like spending limits than contribution limits. Turns out that the Supreme Court punted on that issue. That's one way of describing it. What they actually did is they decided that the limits failed even under the closely drawn, the lesser degree of scrutiny, and that they didn't have to get to the issue. They said, in short, it didn't matter. The challenged aggregate limit failed under the less rigorous standard because the court found, quote, a substantial mismatch between the government's stated objective, which was preventing corruption, and the means selected to achieve it. Mismatch is where they went, a bad fit, regardless of what standard of scrutiny you apply. So, as I mentioned moments ago, the Campaign Legal Center's real concern coming into this was that in the absence of these aggregate limits, joint fundraising committees, a well-known vehicle for fundraising that had, up until this week, been capped in their ability to raise money at about $123,000, that they would become a vehicle to raise $1 million plus checks. How would a joint fundraising committee work? Well, Justice Breyer lays out the math that is in our brief and was in our district court brief that gets you, if you draw it out to the extreme, including every candidate committee in a party, a single party's candidates for every House seat, every Senate seat, and then that party's 50 state committees and 3 national committees, you get to about a $3.6 million per cycle. Now, it's easy to discount that, as Jim has, saying that's not going to happen. Well, pulling together these hundreds of candidates probably isn't going to happen. It could happen under the law today. Probably not going to happen, but I'll tell you what I believe will happen. It's quite easy and far less complicated to pull together the 3 national party committees, a single candidate or a small group of candidates, and the 50 state federal accounts, 50 state party committees. In doing so, you have office holders raising to a joint fundraising committee, which must, under the law, have the candidate's name and the committee's name itself, asking donors for $1 million plus contributions. We're not talking about, as Jim had suggested we're not talking about trying to funnel money to a single candidate, from one donor to a whole huge universe of committees back to a single candidate. We're not worried about that. We think that's impractical, and there's a much easier way to go about this. There is no limit on how much committees can transfer to their own parties. We think that it will be a small number of candidates, a large number of party committees, big checks, and the money will siphon up to the party, and the party's going to spend it wherever it's needed. There are a heck of a lot of candidates out there who are in races that are not competitive and don't need the money. What do they need? They need status within their parties to gain leadership posts. Raising money is the way it was done in the soft money era. Raising money is the way it will be done in the post-McCutcheon era. So we're not necessarily predicting $3.6 million super joint fundraising committees, but we are predicting big checks in excess of $1 million, well in excess of the $120,000 you could have given up until this week. So that's what we think is going to happen. Chief Justice Roberts discounted this in his plurality opinion. He noted that the district court relied on this possible mode of circumventing the base limits through the use of joint fundraising committees, but he characterized it as, quote, unlikely. And he noted that the district court also found it to be unlikely, but the district court was convinced enough that it could be a problem that they relied on it and upheld the limits. Chief Justice Roberts went on to write, in the same paragraph as discounting or dismissing the notion that joint fundraising committees will be used. One problem, however, with this hypothetical use of joint fundraising committees is that the district court speculation relies on illegal earmarking. Now, in my view, one problem with Chief Justice Roberts' opinion in this case is that it relies on a misunderstanding of the law and rules pertaining to joint fundraising committees, and a misunderstanding of how parties and their candidates will actually conduct this activity, and a misunderstanding specifically of the earmarking rules. Under the FEC's earmarking regulation, earmarking is defined as a designation, instruction, or encumbrance, whether direct or indirect, express or implied, oral or written, which results in all or any part of a contribution or expenditure being made to or expended on behalf of a clearly identified candidate or a candidate's authorized committee. Chief Justice Roberts said, see, they can't do any of this joint fundraising committee stuff. They would be earmarked contributions. Contributions to joint fundraising committees need not be, and typically are not, designated for any particular candidate. Candidate makes the ask, the committee exists, the check is cut to the committee, period. There's no need for a donor to write on the memo line of the check that it's designated to go to some other candidate somewhere. And again, I don't think we're talking about a way to use these committees to get a ton of money through a bunch of candidates to another single candidate. I don't think that's what this is about. So I highly, highly doubt that the earmarking rules are going to come into effect in any way in curbing joint fundraising activities, super joint fundraising committees. I just don't think it's going to happen. And if you need evidence of the FEC's own view on earmarking, you need look no further than the disclosure rules for independent expenditures and electioneering communications. What we were told by the court in Citizens United was, don't worry about all this new money, it's going to be fully disclosed. What the court didn't perhaps realize, or at least did not reference in its own opinion, was that there's an FEC regulation that says the only time these outside groups have to disclose their donors is if the donors specifically designate their money for the purpose of running election ads. What have we seen since the Citizens United decision? Over $400 million in expenditures by groups that haven't disclosed their donors because their donors didn't earmark their money for election ads. Earmarking rules don't do much, and they haven't done much in the last 4 years. They're not going to do much in the coming years. So, in fact, we know that joint fundraising committees are quite common. They are required to have a candidate's name in the joint fundraising committee's name, and contributions to joint fundraising committees have never been treated by the FEC as contributions earmarked to any of the candidates involved in that joint fundraising effort. And there is no restriction whatsoever on the parties who raise money through a joint fundraising committee named after a candidate who solicited it from using every penny to support that candidate, either in the form of coordinated expenditures or so-called independent expenditures. And the weakness of the rules on coordination and independent expenditure is a topic for an entire other symposium, so I won't go into it. But you don't need to believe me in my skepticism about Chief Justice Roberts' view that use of joint fundraising committees in this manner is unlikely. Believe some lawyers who represent these groups. Yesterday, Peter Overby had a piece on NPR where he didn't go straight to reformers. I talked to Peter occasionally. He occasionally quotes me. Not this week. Who did he call? He called Robert Kellner, who's the chair of Covington and Burling's political law practice group. Rob mostly represents conservative groups, Republican candidates, parties, etc. What was Rob's view on this? Quote, the main effect of this decision is that it's going to encourage the development of super joint fundraising committees, close quote. Who did Peter call next? He called Ken Gross, head of Skadden Arp's political law practice group, mostly represents Democrats, some conservative groups. Ken, quote, well, the wallets of many of my clients are already rattling. This is going to be a costly decision for high-end donors, close quote. And Ken went on to explain how his donors really liked having the cover of an aggregate limit. They could say no when they were solicited. No longer. If they want to get their calls answered on the Hill, if they want to get their meetings, they're going to have to open up their wallets much wider than they had to in the past. So I'm going to conclude by asking, at the end of the day, whether any of this really matters, at least the details about earmarking, the details about joint fundraising committees, the details about the aggregate limits. What's left standing post-McCutcheon? Disclosure, I argue yes, because disclosure is supported by an entirely unrelated governmental interest in informing voters, a voter information interest that was not at issue in McCutcheon, that 8 of the court's 9 members in multiple recent decisions have supported. So disclosure, I think, is still on the table and not particularly vulnerable to challenge. But how about soft money? As I mentioned earlier, the Citizens United Court backed away from the soft money question and just said this case is about independent expenditures, not soft money. What did the McCutcheon court say about soft money? Chief Justice Roberts wrote in a footnote, the fact that this opinion does not address the base limits also belies the dissent's concern that we have silently overruled the court's holding in McConnell. An issue in McConnell was BICRA's extension of the base limits to so-called soft money, previously unregulated contributions to national party committees. Our holding about the constitutionality of the aggregate limits clearly does not overrule McConnell's holding about soft money. But I ask all of you, given that we can now only regulate money in politics to prevent corruption, And given that corruption now equals only a direct exchange of an official act for money, and that a substantial mismatch, any substantial mismatch in Chief Justice Roberts' view, between the only acceptable governmental interests, in this case, preventing a direct exchange of official acts for money, are there any restrictions on money in politics besides the long-existing basic anti-bribery law that can survive a challenge before this Supreme Court's majority? Regardless of whether one equates the aggregate limit-free fundraising that will be done by office holders post-McCutcheon to equate to a return to soft money, the BICRA soft money ban itself may soon be on the chopping block.